Yes, Mr. Chairman.
May it please the Court, I appear in this matter with Mr. Parfitt for the appellants. My lone friends Mr. Parker and Mr. Matthew Smith appear for the respondents. Just by way of preliminary, the Court of Appeal gave judgment in this case on the 17th of June 2016. But since that date, the particulars of claim have undergone significant amendment. Yes. Now, there are two aspects of that I'd just like to draw to the Court's attention. The first is that the claimant now pleads fraud and alleges that there is no applicable limitation period by reason of Section 21(1)(a) of the 1980 Act. Now, that issue isn't the subject of this appeal. Secondly, to understand the Court of Appeal judgment, it's necessary to know that the claim as then advanced turned in large part upon an allegation that there had been no revaluation of the vital share that was the subject of the distribution in specie. The claimant no longer advances that claim, and indeed it now alleges that there was a revaluation, but seeks to impugn the distribution on other grounds. So the judgment below focused on the transfer of the share in vital by way of dividend. Those shares were the property under consideration for the purpose of Section 21(1)(b), and the question of who had possession of that share. Now, as the Court will have seen from the respondent's written case, that the respondents now rely heavily upon the relevant property being the benefit of a corporate opportunity taken by the defendants. The corporate opportunity claim was before the court below on the pleadings, but that's not the way that the Court of Appeal looked at the case. And then, finally, by way of preliminary comment, this hearing is not about whether or not the company has a claim against these directors. It's about whether any claim that it may have pleaded, apart from fraud, is subject to a period of limitation. It's not a question of whether the company has a remedy in respect of any wrong done to it. It's about whether the company has sought to exercise that remedy in time. And just for your note, the relevant transaction, as the Court of Appeal found, took place on the 12th of October 2007. Administrators were appointed over the company on the 2nd of October 2008. The company went into liquidation on the 7th of December 2009. And the claim was issued on the 15th of October 2013 and served on the 12th of February 2014.
Yes.
So far as Section 21 of the Limitation Act is concerned, we can see it at the Authorities Bundle, Tab 1, so Bundle 1, Tab 4. Paragraph 21(1). For the purpose of this appeal, the defendants accept that the relevant limitation periods governing claims against them for breach of fiduciary duty are as set out in Section 21 of the Limitation Act 1980. Nonetheless, the defendants are sued as directors of the claimant company. Questions of corporate personality cannot be ignored. And thirdly, concerning limitation, there's no dispute but that where a defence of limitation is raised, the burden is on the claimant to show that limitation does not apply. Now, the respondent's case is that any benefit received by a fiduciary who is accountable is trust property. Respondent says that FHR provides that a wronged beneficiary has a proprietary claim against the fiduciary, and that equity will look through to the ultimate benefit received by the fiduciary and will treat that as trust property in the fiduciary's hands. The claimants say in particular, in this case, that the opportunity to sell an interest in Vital, the company's subsidiary, to SSE was a corporate opportunity of the company, and that the benefit of this transaction was wrongly taken by the defendants. They say that that benefit is itself trust property because it is held on constructive trust for the company, for FHR. Now, there are two answers to this. The first is that a Boardman and Phipps, Regal Hastings and Gulliver type duty in respect of a corporate opportunity can have no application to a transaction which involves the distribution of the relevant asset and necessarily any opportunity associated with that asset to the sole member of the company. And I say necessarily any opportunity associated with that asset because it must follow. If the company has an opportunity to sell some land and then it distributes that land to its members, then the members now have the opportunity to sell that land because they've got the land. The company has distributed both the property and the opportunity that went with that property. If one looks at Regal Hastings very briefly, it's well known, and there's only a short passage I'd like to take you to. It's at the Authorities Bundle A, tab 11. At page 146 of the authority, rather than the bundle.
Can you give us the electronic number as well, please?
The electronic reference is 116.
116, thank you. Yes?
And the passage starts right at the bottom. It's the last line on that page. My lords, I have no hesitation in coming to the conclusion upon the facts of this case that these shares, when acquired by the directors, were acquired by reason and only by reason of the fact that they were directors of Regal and in the course of their execution of that office. Now, necessarily, property and any associated opportunity which is acquired qua shareholder is not acquired qua director. Secondly, the question of accountability turns on the knowledge of the principal. And in the context of a company, this means, or at least includes, the knowledge of the shareholder. Now, we would agree that the knowledge of the shareholder cannot protect the directors against an allegation of breach of duty in failing to have regard to the interest of creditors. In other words, if the interest of creditors intervene, the knowledge of the shareholder will not mean that directors can act in breach of their duty to the company to have regard to the interest of creditors. So, if the removal of the vital share and any associated corporate opportunity was a breach of duty, in the sense that the directors failed to have regard to the interests of creditors, as is alleged, then we accept that the directors responsible may be liable to compensate the company accordingly. But they will be compensating the company for that which it has lost, namely the asset with its value, with the associated opportunity. But the knowledge of the shareholders does protect the directors against a Regal Hastings claim. The no profit rule and the no conflicts rule, as between a company and a director, are rules which don't respond to questions of solvency or insolvency, because those are equitable principles and they derive from the relationship between the director, the company, and the shareholders. If the constitution of the company permits directors to act where there is a conflict of interest and duty in certain circumstances, and after all, the Boardman and Phipps line is very much founded on questions of conflict of duty, as much as the profit rule. If the constitution of the company so permits, then it's neither here nor there that the company is solvent or insolvent. The director's conflicts rule is governed by the constitution of the company. Equally, the profit rule, to the extent that the constitution of the company so allows. And at common law, it's the shareholders who can determine whether or not a director is entitled to take a profit arising out of his fiduciary obligation. But that has nothing to do with the question of whether the company suffers a loss, which goes to damage the interest of creditors. I just note by way of aside that the Companies Act 2006, which incidentally this transaction straddles in the sense that Section 172 of the Companies Act had come into force at the time of this transaction, but the conflicts provisions of Section 175 of the Act hadn't come into force at the time of this transaction. So one's actually dealing with the statutory duty of directors to act in the best interest of the company, but the conflicts provisions remained at common law. And just by way of aside, it's Section 1723 of the Companies Act which qualifies the director's obligation to promote the success of the company for the benefit of its members by saying that that obligation is subject to the common law rule that in certain circumstances directors have to have regard to the interest of creditors. But if one looks at the conflicts provisions of the Act, which have now come into force, and I say the same is true of the common law, those conflicts provisions don't have any similar saving in respect of the interest of creditors. It's nothing to do with creditors.
You're going to come to this in a little more. I mean, I'm not at the moment quite following where this takes us. But, I mean, if you're wanting to rely on something in the Act, we better look at it.
Well, I'm not relying upon it because the relevant provisions weren't, well, a provision is in force, was in force at the relevant time. It's simply by way of aside.
If it's aside, then I can forget about it. But if you're relying on some difference between a provision which was in force and one which wasn't in force, then I need a little more help.
My Lord, no, and I didn't mean to confuse the issue by doing so. It is an aside. It's simply to say that when one is dealing with questions of directors acting in breach of their duty to act in the best interest of the company, shareholders can't sanction a breach of that if it damages creditors. That's straightforward. But when it comes to looking at the questions of the no conflict or no profits rule, the equitable obligations that are established by Boardman and Phipps and Regal Hastings and Gulliver, those provisions are not provisions which respond to the creditors. The shareholders in general meeting can always sanction a director to act in a way which would otherwise be in breach of the conflicts rule or the no profit rule. So they can't sanction the director causing damage to the company. They can't say creditors can be prejudiced by our act, but what they can say is that those particular equitable rules will not apply to the directors. So creditors can complain about the removal of assets which would otherwise be available to them. That's the idea that when a company becomes insolvent, one looks at it in terms of a notional liquidation. Creditors have a notional interest in the assets of the company because of the insolvency, and directors can't give those assets to the shareholders. But what the creditors don't have, unlike shareholders, is the right to recover assets regardless of whether those assets will be available to meet their claims. So they can be compensated for what they've lost, but they can't be compensated for that which they could never have obtained. And we know that the rule in Hastings and Gulliver and Boardman and Phipps is so strict that it applies even where the company could not itself take the opportunity. So if we just consider the SSE opportunity for a moment, there's an issue between the parties about whether it was open on the pleadings, about whether it was open to the company to exploit the SSE opportunity. The claimant says it was, the defendants say it wasn't. The defendants say SSE insisted that Vital be demerged from the company before it would participate, and that's going to be an issue at trial. But you can look at this from, looking at this from the Boardman and Phipps analysis. If the Boardman and Phipps analysis applies, it doesn't matter whether the company could exploit the opportunity. The directors would be held accountable for their profit in any event unless they took that opportunity with the knowledge of the shareholders. That's basic Boardman and Phipps. But the creditors will not have lost by the removal of that opportunity, or the removal by the taking of that opportunity by the directors. If the company couldn't take the opportunity, that was never available for the creditors. The creditors have never lost it. So there's a distinction in principle between an action against the director in respect of the loss that has been caused to the company, and an action against the director to recover something that the company could never have had, but which the director has taken by the use of his fiduciary position. Now, in this case, we have a very straightforward position that the company distributed the asset to its shareholder. And we know that, in accordance with Regal Hastings and Boardman and Phipps, the shareholder can give approval to the diversion or the taking of a corporate opportunity by a fiduciary. Well, here, the asset and the opportunity itself was washed through the distribution. It went through the shareholder. So there can't be a Boardman and Phipps type claim in respect of these proceedings. Now, I hope the court won't mind when I say that actually none of that matters so far as this court is concerned, because even if the directors were accountable in respect of the corporate opportunity that they exploited, the jurisprudence on Section 21 makes it clear that a claim which is proprietary by reason of the principles set out in FHR is not property within the meaning of Section 21(1)(b), and that remains so even if the person against whom the claim is brought is a fiduciary. The claim is what has become known as a Class 2 constructive trust. You can see that come to the authority. Now, before the Court of Appeal, the discussion turned on whether the defendant had, within the meaning of Section 21(1)(b), come into possession of the shares in Vital, or the share in Vital. And that was a discussion concerning a Class 1 constructive trust, the type that we'll see, because the property was trust property in respect of which the defendants had fiduciary obligations prior to the alleged wrongdoing. But based on FHR, the exploitation of a corporate opportunity could at best give rise to a Class 2 constructive trust, because the opportunity wasn't property of the company prior to the alleged breach. Statement to that effect by Lord Cohen at page 103D of Boardman and Phipps, but I don't think we need to turn that up, because I think it's clear per FHR. It could only become trust property as a result of the breach. Now, there's a significant body of authority to the effect that a Class 2 constructive trust does not give rise to property to which Section 21(1)(b) responds. And I think the easiest way to look at that is from the Court of Appeal decision in first sub-C. And you'll find that in the appellant's supplemental bundle. Now, this decision of the Court of Appeal is, I believe, a decision in respect of which permission has been given to appeal to this court. But I don't think that matters, because if the appeal succeeds, that will only assist or may assist the defendant in this case in respect of Section 21(1)(a). That, I think, is the issue that will be the subject of the appeal. So far as 21(1)(b) is concerned, this case very conveniently sets out, with some clarity, the position. And the first thing I just want to note is that Burnden was mentioned in this case at 899C to D. And you'll just see the way that's put at C. Mr. Cavender, Queen's Counsel for Mr. Emmett, contends that the judge was wrong to treat the breaches of fiduciary duty as fraudulent because no allegation of fraud was properly pleaded or advanced during the hearing. That was an issue that we had below as well in the Court of Appeal, and the Court of Appeal held that on the pleadings as they then stood, there was no allegation of fraud. Mr. Marshall, for the claimant, contests this, but also relies on the recent decision of the court in Burnden and Fielding as establishing that a claim for an account or equitable compensation, which the judge did order, is sufficient to bring the claim within Section 21(1)(b). Now, I think what was going on there was that Mr. Marshall was relying on a passage from the Court of Appeal judgment, which you'll find in the appendix. Appendix bundle at tab 2. Electronic bundle page 13, paragraph 38.
Sorry, I don't think it's 13, is it?
No, it's no.
I'm very sorry. In my bundle, it's showing at 13. The paragraph is 38. So this is.
Well, I still need the electronic page number, please.
The appendix, tab 2. My bundle is showing at 13.
Well, that's not right. In any event, what is it you want us to look at?
It's a Court of Appeal judgment in this case.
Yes.
Paragraph 30.
Starts at 74.
Starts at 74.
The practice direction does require counsel to be familiar with the electronic bundle numbering.
Yes, my Lord, I
Well,
believe.
which paragraph do you want us to look at?
It's paragraph 38.
Thank you. That's at page 82. It'd be helpful if your junior could get the electronic numbering so that we don't have this difficulty throughout. Yes?
Thank you, my Lord. My
Yes.
junior will attempt to do that.
Yep.
Paragraph 38. Lord Justice David Richards, Mr. Chivers also objected that an account of profits is not within Section 21(1)(b). I'm inclined to agree, but the remedies sought by the claimant include equitable compensation, and that appears to me to be an appropriate remedy falling within Section 21(1)(b), particularly where, as in the case of Mrs. Fielding, the trustee's indirect interest in the trust asset has been converted to the use of the trustee. I don't know, but I think that's what Mr. Marshall may have been referring to. But what we're concerned with at this part of the submission is not the direct property, namely the share in Vital, but we're concerned with a benefit in respect of the corporate opportunity. And so far as that is concerned, the analysis in first sub-C, I think, is unaffected by that. One can pick it up, I think, in the supplemental bundle. At 907 D, where there's an account of how the judge dealt with this. So far as Section 21(1)(b) is relied upon, that provision is concerned with wrongful dealing with pre-existing assets that had been entrusted to the fiduciary, as where a director abuses the power of disposition which he has over company property. This, however, in one alternative, is a claim to an account of profits, which came into existence by reason of the breach of fiduciary itself, in respect of which Mr. Emmett is to be treated as if he were a trustee. And then at paragraph 35, there's a reference to judgment of Lord Justice Millett in Paragon Finance. And at paragraph 36, having dealt with the two classes of cases described by Lord Justice Millett at paragraph 35, the second of the two classes of case described in this quotation is...
Sorry, where are you reading now?
Sorry, paragraph 36 now. I'm sorry, I was taking as read the passage from Lord Justice Millett in Paragon Finance. Perhaps it would be sensible for the court to read that.
And that's the difference between the Class 1 and Class 2 constructive trust.
That's right, yes.
Yes.
And so, going on at 36, the second of the two classes described in this quotation is where the defendant is not a fiduciary at the time of the fraud, and the constructive trust, if it arises at all, is simply no more than a formula for equitable relief. But the same reasoning is capable of applying to existing fiduciaries, such as agents who do not hold trust property but who commit a fraud which gives rise to the imposition of a constructive trust. A good example is the recent decision in FHR. So the decision that my learned friend is relying on is expressly considered by the Court of Appeal here. It was held that an agent who receives a bribe or secret commission in his capacity as an agent holds the proceeds on constructive trust for his principal. The Supreme Court rejected the argument that the trust should only be imposed where the payment arose out of an opportunity which came to the agent as a result of his fiduciary position. In such a case, the payment or other benefit can be regarded as part of, or at least derived from, the property of the principal, which equity therefore recognises and protects by the grant of a proprietary remedy. Supreme Courts instead adopted a wider principle, advocated by a number of critics, including Lord Millett, that any benefit which results from a breach of fiduciary duty to the principal is held on trust for him. In such circumstances, the agent cannot rely on his own breach of duty in order to claim the benefit for himself. He will be assumed to have acted in accordance with his duty to have acquired the benefit for his principal. And then at 37, the consequence of this is that constructive trust will be imposed on fiduciaries in such cases, regardless of whether it's possible to treat the benefit or payment received by the agent as derived from property in which the principal had a pre-existing interest. This is consistent with cases like Phipps and Boardman, decision in Buller and Buller. And then, at paragraph 38, the discussion turns to the Trustee Act. And the discussion of Taylor and Davis at paragraph 40, between G and H, the defendant in Taylor and Davis was a member of the Committee of Inspection of an insolvent firm whose assets had been assigned for the benefit of creditors, who was accepted to be a fiduciary in relation to the exercise of his powers of inspection, but he did not hold the property of the insolvent. The question arose whether a claim made against him for the knowing receipt of assets held in trust by the assignee was subject to a period of limitation. Privy Council held the claim was statute barred. In relation to the definition of trustee as including constructive trustee, Viscount Cave said, expressions trust property and retained by the trustee properly apply not to a case where a person having taken possession of property on his own behalf is liable to be declared a trustee by the court, but rather to a case where he originally took possession upon trust for or on behalf of others. In other words, they refer to cases where a trust arose before the occurrence of the transaction in peach, and not cases where it arises only by reason of that transaction. The exception, no doubt, applies not only to an express trustee named in the instrument of trust, but also to those persons who, under the rules explained in Sawn Ashwell and others, to be treated in a like position.
Those persons include directors, don't they? The Sawn Ashwell.
Yes, Sawn Ashwell, I think,
class.
is disapproved subsequently. Yeah.
I'm sorry?
I think Sawn Ashwell, Malone Jr. will find there's a further reference to Sawn Ashwell. I'll come back to that if I may, my lord.
Well, it was partially overruled in Williams.
I'm grateful for my lord. It was Williams that it was partial, rather than first subsea. I'm grateful. Then, paragraph 41, in Paragon, Lord Justice Millett explained the reasoning in these cases, section 1.3 of the Act, went on to explain why he considered the provisions of section 19, now reenacted, had preserved the distinction between the two classes of constructive trusteeship. And then, at H, these passages recognise the gateway to section 21 is the definition of trust and trustee in section 38.1. The protection afforded to beneficiaries depends on the status of the dependent at the time he commits the breach complained of. This is a question of statutory construction, for which Taylor and Davis provides an answer which has now been adopted in relation to section 21 of the 1980 Act. And then there's reference to Paragon having been affirmed in Williams, a reference to the Hong Kong Court of Final Appeal, Lord Hoffman in Peconic, where again, and one can pick it up at D, for the purpose of limitation, however, there are two kinds of constructive trustees. Distinction between them has been explained by judges on numerous occasions. First, there are persons who, without any express trust, have assumed fiduciary obligations in relation to trust property. Example is purchaser on behalf of another, trustee de son tort, company director, or agent holding the property for a trustee. So a company director is included there. I shall call them fiduciaries. They are treated in the same way as express trustees, and no limitation of period applies to their fraudulent breaches of trust. Then there are strangers to the trust who have not assumed any prior fiduciary liability, but make themselves liable by dishonest acts of interference, non-fiduciaries. They're also constructive trustees. This is nothing more than a formula for equitable relief. They're not constructive trustees within the meaning of the law of limitation. And then that was adopted in Williams, where, concluding at D on the next page on 3, again, the reference is one to the constructive trust, type 2 being purely remedial. The distinction between these two categories is not just a matter of the chronology of events leading to liability, it's fundamental. Words of my Lord Sumption. It's the distinction between an institutional trust and a remedial formula, between a trust and a catchphrase. Having returned to Taylor and Davis, Clarkson and Davis, Sumption went on that analysis of section 1 has been accepted by the English courts at every level below this court. Reference to Paragon Finance. And then reference to Catley and Pollard and Sheldon, Queen's Counsel, but then applied only to express and de facto trustees, not to persons liable only by virtue of their dishonest assistance. In J.J. Harrison Properties, and I mention that because this is a case that's relied on by my learned friend, again in Gwemby Valley, Court of Appeal adopted the analysis of Lord Justice Millett, applied it to a case of knowing receipt of the assets of a company, held in both cases that no period of limitation applied, but only because the defendant was a director and as such to be treated as a true trustee. Halton International, the Court of Appeal adopted the same reasoning, held that Section 21(1) applied only to claims against express or de facto trustees, not to claims against constructive trustees whose liability came into being as a result of the transaction impeached. And then there's the reference here in Peconic, says Lord Hoffman, delivering the leading judgment, declined to follow the dicta of the Court of Appeal in Saw and Ashwell, which he regarded as wrong in principle, unsupported by authority. And then at 45, a defining characteristic of constructive or de facto trustees within the first class, the Paragon case, is that, as with all trustees, they should be in lawful possession of trust property. In the Paragon case, Lord Justice Millett did not attempt any exhaustive summary of all the various types of fiduciary that might fall within this class, nor was he concerned to deal with the position of directors. But in J.J. Harrison Properties, their status as Class 1 fiduciaries was confirmed by the court in a case where a director purchased land belonging to the company without disclosing to the board that it had potential development value. And this was ultimately realised and the land was sold by the director for a significant profit. The company took proceedings on the ground the director had allowed his personal interest to conflict with those of the company, was in breach of the equitable rule against self-dealing. The judge held the transaction was liable to be set aside. The director must account for the profits he had made. And then Lord Justice Chadwick set out various principles, but I would pick it up at paragraph 29 of his judgment, which is over the page 915D. There's no doubt that Lord Justice Millett regarded it as beyond dispute that a director who obtained the company's property for himself by misuse of the powers which he had been entrusted as a director was a constructive trustee within the first category. He referred to directors and other fiduciaries. There's no doubt he was correct to do so. The reason is that a director on the appointment of that office assumes the duties of a trustee in relation to a company's property. And then this is an interesting part for something that we'll come on to in respect of the next aspect of the appeal. If thereafter he takes possession of the property, his possession is coloured from the first by the trust and confidence by means of which he obtained it. His obligations as a trustee in relation to the property do not arise out of the transaction by which he obtained it for himself. The true analysis is that his obligations as a trustee in relation to that property predate the transaction by which it was conveyed to him. The conveyance of the property to himself by the exercise of his powers in breach of trust does not release him from those obligations. He is trustee of the property because it has become vested in him. But his obligations to deal with the property as a trustee arise out of his pre-existing duties as a director, not out of the circumstances in which the property was conveyed. Now, the court will immediately see that there, Lord Justice Chadwick is drawing the distinction between the fiduciary obligations of the director while the company is in possession of the property, with the possession of the property that is subsequently obtained by the director. And that's the point at which his pre-existing fiduciary obligations bite on that property, and they render him a Class 1 type fiduciary. We can come to that in a little more detail, but for the purpose of this aspect of the argument, the court needn't be concerned with it. And then at 47, the position is said to be less clear when the director's breach of duty does not involve the misappropriation of company property, but is a fraudulent breach of duty which, if committed by anyone but a Class 1 fiduciary, would give rise to a constructive trust of the Class 2 kind. Mr. Cavender's argument is that Section 21 has no application to the second type of case, even where the fraudulent breach is that of a Class 1 fiduciary. It's limited to cases where the fiduciary misappropriates or misuses property already vested in him or under his control. The focus of Section 21 is on the nature of the cause of action rather than on the identity of the person who commits the wrong. So in the present case, Mr. Emmett, although a director, has not appropriated or disposed of company property under his control. His breaches of duty have been ones of disloyalty, making him accountable for the loss caused to BSW. But no constructive trust has come into existence, and even if it had done, it would have been of the Class 2 kind, i.e. part of equity's response to the claim for relief. Now, the court will see that in first subsea, it was being argued, and it had to be, given the findings, that even a fraudulent breach of duty would not, Section 21(1)(a) wouldn't respond to that in respect of a Class 2 type trust created where there's been a fraudulent breach of duty. And that I think, is what the appeal in first subsea will be about. We're concerned, for the purpose of this argument, not with a fraudulent breach of duty. So we're concerned with a breach of duty that is not fraudulent. And then this is the point referred to by Mr. Justice Norris in paragraph 473 of his judgment. The controversy centres on the decision of the court in Gwembe Valley. This is a case in which the managing director of a joint venture in Zambia arranged finance for the company in US dollars through another company, which he controlled, was able in the process to make a very large undisclosed profit on currency transactions for his own benefit. The joint venture company failed, and its receiver subsequently sued the director on behalf of the company for an account of profits or equitable compensation for breach of fiduciary duty. A declaration was also sought Mr. Koshi was liable as constructive trustee for all of Gwembe's money which he received. The trial judge held that Mr. Koshi was not liable as constructive trustee, dismissed the claim for equitable compensation for dishonest breach of fiduciary duty. But he held that Mr. Koshi was liable to account for the profits on the basis that he had acted dishonestly in using his position as managing director to profit at the expense of the company. On appeal, the Court of Appeal held Mr. Koshi was entitled to the benefit of Section 21(3), either directly or by analogy, subject to the provisions of Section 21(1). Giving the judge...
If you're going to read large tranches of these judgments, you might consider inviting us to read them ourselves rather than you simply read them out.
My Lord, I'm grateful for that indication.
Nice to know where all this is going.
Yes.
Right.
Yes.
I mean, I see it's coming out to a controversy about what we said in Gwembe, which I commented on a later case, and I sort of vaguely remember all that, but I'm hoping it hasn't got anything to do with this case.
Well, my Lord, where it comes to is that at paragraph 54, paragraph 53 is where it comes to, that the claim against Mr. Koshi didn't fall within Section 21(b). So he was a Class 1 fiduciary, but he had not misappropriated part of its property. So he had made a secret profit for which he's accountable, but that's a Class 2 type trust. Yeah. And even though he was a Class 1 type fiduciary, 21(1)(b) acted to protect him. And that is then dealt with by Lord Justice Mummery, paragraphs 112 to 120. And I would ask you to read from E to H, and the conclusion just to the bottom of the page.
Thank you.
Sorry, which page?
Page 917.
Yeah.
It's paragraph 54. It's the Lord Justice Mummery.
Yeah.
You're adopting what was said
I'm
by Lord
adopting what
Justice
was
Mummery
said there.
in a judgment of the court.
Yes.
And I was apparently unhappy about what we said about 21(1)(a), but that doesn't affect our
exactly.
argument today.
Exactly. I think it was my Lord's comment that set the hair running on on the 21.1a point.
Yes. Well, we don't need to go there today.
We don't need to go there today.
Good.
The 21.1b point is
Yes.
not in doubt.
Yeah.
And ultimately, having dealt with the Holton International case, which was a similar case, which dealt with the paragraph 53 and 57, 57 noting that those cases were referred to by my Lord Sumption in Williams. The conclusion of 59 is that 21.1b does not apply to the Gwenby type case where there's no misappropriation or receipt of pre-existing company property.
It really all goes back to Taylor and Davis, then, does it?
It goes back to Taylor and Davis, yes, Mark. Now, I think we can leave that there because there is, I think, as it appears from that discussion in First Subsea, which is the most recent gathering together of the authorities in the case, there is a significant body of authority, not directly in this court, but certainly in cases that have been approved by or commented on without disapproval in this court. There's a significant body of authority to the effect that a Class 2 constructive trust doesn't give rise to property to which Section 21.1b responds.
Yes.
And that very shortly means that insofar as the claim is a claim in respect of the diversion of a corporate opportunity, if that was done without fraud, the limitation period is 6 years. My Lords, can we now turn back to the Court of Appeal decision and the electronic bundle reference here, page 79,
Thank you.
to the passage that I'd ask you to look at.
Yes.
Sorry, can you give me the page number again?
Yes, the electronic bundle reference is 79.
79.
Yes.
Which paragraph?
Paragraph 29.
Yes.
Yeah.
And just the first thing to note there is that this was the question as to when the cause of action accrued. What was the date of the transfer? And the relevant transfer was held to be on the 12th of October 2007. I reject the submission at the end of that paragraph that a cause of action accrued on the 15th of October and satisfied the company's cause of action against the defendants accrued on the 12th of October. So that's the date of the distribution of the company's share to BHUH, the company's sole shareholder. Then if we can move on to page 81 in the electronic bundle, paragraph 35.
Paragraph
35.
35.
35.
A literal reading of section 21.1b supports the submission made on behalf of the defendants, but it means that its effect can very easily be avoided by trustees who, whether knowingly or otherwise, transfer trust property in breach of trust for their own benefit. The use of companies to hold assets where the beneficial ownership of the asset is vested in the company, but the entire economic benefit is available for the shareholders, has of course been commonplace for many years. where the receipt of trust assets in breach of trust is likely in many cases to be structured in this way, it would be surprising if Section 21(1)(b) was intended to apply only in those cases which fell within its terms on a very literal reading. Now, three things I'd say about that. The first, of course, is that Section 21(1)(b) is not dealing with the fraudulent breach of trust. The second is that 21(1)(b) is not dealing with questions of concealment. That's Section 32. And thirdly, there's no doubt that the separate corporate personality of an entity interposed for the purpose of avoiding the provisions of Section 21(1)(b) could be ignored, notwithstanding the separate corporate personality. And that's clear from the general principles set out in Prest, and we can just find a quick statement of that. Electronic bundle at page 750. It's in the physical bundle at bundle B at tab 19.
What page?
Sorry.
Or paragraph?
The physical bundle, it's at 433 of the judgment. It's 750 of the electronic bundle.
We're looking at paragraph 35.
Paragraph 35. So I should ask you to start just before at 34. My notice is quite right from the previous page, starting at 34. If my lords would just read 34.
I'm sorry, Mr. Chivers, you want us to start at
Yes, I'm so sorry. I'd asked you to start at 35. Would you please read 34 and 35?
At page 487 or 433?
487, starting at 487 of the judgment and moving to 488.
Yes.
So, my lords, the suggestion by Lord Justice David Richards that the operation of the section could, on a literal meaning, be easily avoided by the interposition of a company is wrong. Any attempt to avoid it by the interposition of a company, it seems, would be bound to fail. But if a company has been interposed or is there and there is no intention to avoid, then it's simply a fact. And just as paragraph 54, Lord Sumption made the point that the principle can't be, or there is no principle that the liability of the company is the liability of the controller, so equally, we say here, there can be no principle that the possession of the company is the possession of the controller. We'll go on.
Is possession really the right concept? The question is whether this is an action to recover from the trustee property or the proceeds of trust property in the possession of the trustee. Normally the position is surely that if the trustee misapplies the trust fund, the law will treat him as continuing to be in possession for the purpose of requiring him to restore it. And if that is the nature of the obligation, on the face of it, 21(1)(b) applies. I mean, I think that's also a point made in Williams.
With respect, my lord,
Because a director is a true trustee.
Yes, but as we've seen from the Class 1 and Class 2 cases, the law may treat someone as being a constructive trustee. In other words, may say we treat you as still being a trustee. But the fact is that a person may not be in possession of the property. Now, it's all very well for the court to say, well, where there has been a misappropriation, we treat you forever as being in possession of the property. But that would beg the question as to whether it was actually possession of the property that has been taken from the company. If that property is in someone else's possession, it can't be in the director's possession at the same time. And to say that the law employs a fiction and says, well, we will hold that director accountable, it's exactly that remedy, that's a remedial trust that's being imposed. Saying, we accept you don't actually have possession of this, but we're not going to allow you to say for these purposes that you're not accountable to the company.
If you have if as a trustee you have an obligation to reinstate the fund forthwith after its wrongful removal from the company beneficiary, and you control the entity which is in possession, are the requirements of 21(1)(b) not made out?
My lord, I will come on to control, if I may,
All right.
in due course. I will address that in the context of control. But first of all, I just wanted to deal with the argument, so to speak, on the face of the section and for Justice David Richards' points about avoidance. And I say that there's no need to strain the meaning of possession beyond its ordinary bounds, because if you do attempt to avoid the provisions of this, if you use the interposition of a corporate personality to attempt to avoid recovery of funds, the court will look through that. So that's very clear. The question the question we're concerned with is the non-fraudulent case. And
I'm sorry, say it again, please.
We're concerned with the non-fraudulent case.
Yes.
And with the person who is not putting the corporate entity in place so as to avoid recovery. So that it has the interposition of the corporate entity is, if I can put it this way, innocent. It's not dishonest. So,
Can I make sure
Yes.
I understand what the limits of your argument are? You accept, I think, don't you, that as a Class A trustee, a director is in, if you like, is in a trustee relationship with all the property of the company. It's his duty to husband that property for the company. That means that he's a Class 1 trustee in relation to it.
I accept that he has fiduciary obligations in respect of it, and I'm going to come on to Lord Justice Chadwick's analysis in Harrison, which puts a gloss on that, where he says that he becomes a trustee when he receives the property from the company because he has fiduciary obligations in respect of it. If one thinks of...
He's a trustee before that, isn't he?
Well, that's my
But
question. Surely he's a trustee.
with respect, he isn't actually a trustee before that. A director, as the cases say, is not actually a trustee of the company property.
Well, the trouble about that is that there's a good deal of authority which has established the opposite proposition.
Well, with respect, my lord, I'd say that authority establishes he has trustee-like duties. He has trustee-like duties.
Well, he is treated as a trustee, although it is of course true that the property is not actually vested in him, but his control is treated as tantamount to possession. I mean, that was essentially the point that was made by Lloyd Thomas in Selangor, perhaps the only point in that judgment which can be treated as irredeemably correct. And it was endorsed in Williams.
My lord, there's no doubt when we're looking at the duties of the director, we can equate them for these purposes with the duties of a trustee. But to say that a director has in their possession all the property of the company is a misstatement. It's a misuse of language. The director does not have the property in the possession.
Well, he has control over it.
Well, the director, subject to the constitution of the company, has control of the property.
So are you
but that doesn't.
That a director can only effectively be a constructive trustee when he misapplies that property?
Well, my lord, to make him a constructive trustee, he becomes a Class 1 constructive trustee if he takes that property into his possession, his personal possession.
Yes, but you're submitting that that is the only kind of trusteeship which a misapplying director can have. Is that the position?
My lord, what I say is
how far your submission goes.
My lord, what I say is this: if the director takes company property in respect of which he is a fiduciary, he becomes, when he holds that property, a Class 1 constructive trustee in respect of that property.
And is it your submission that that is the only basis on which he can be treated as a trustee?
Well, my lord, it depends on the purpose for which one is using that expression. We say that a director is like a trustee in certain respects, but he is not actually a trustee subject, for example, to the Trustee Act in respect of his obligations. The director is a director of the company subject to statutory obligations which are set out in the Companies Acts and in a body of common law. And that director's obligations are different from the obligations of trustees.
Yes.
It is not the same as a trustee. However,
the
director has fiduciary obligations to the company, and insofar as those fiduciary obligations are under discussion, those are trustee-like obligations.
We're now getting, you established that Section 21(1)(b) is not concerned with Class 2 constructive trusts. We're now getting to a slightly different question, which, given that the director has Class 1 type responsibilities to the property, is that enough to sort of bring him within 21(1)(b) by that route?
And my lord, that's exactly the point that we have to consider.
And is there authority which establishes that?
Well, my lord, I will take you to what Lord Justice Chadwick and how he analysed this in the Harrison case, which is a case, if one's looking for a case where this has actually happened, one can see it happening in Harrison. And one can see the analysis of Lord Justice Chadwick, and I would say that that's correct.
I mean, in Williams, and I'm thinking of paragraph 9, and again at paragraph 28, when the various decisions of the Court of Appeal which preceded that case are considered.
Where do we find that?
Page 500 MS. It seems to me fairly clear that we held that in respect of limitation.
Can I get that again? 21 paragraph.
It's MS 500, paragraph 28, letter G, where Harrison and Gwemby are analysed with approval on the footing that no limitation period applied because a director is to be treated as a true trustee, which is an expansion of the point previously made at paragraph 9 and by reference to Selangor at paragraph 10.
My Lord, I accept that for limitation purposes, if a director takes company property, then Section 21(1)(b, so far as he has that company property, will treat him as if he is a true trustee. But if the director does not possess the company property, he is not treated as possessing it, even when he doesn't have it. That's all my point is.
I understand.
It's not that he is not under an obligation on receipt of that property. It's not that he is not under fiduciary obligations in respect of the company. But as I'll come on to, control is a very slippery concept when you're looking at questions of possession.
Possession doesn't in 21(1)(b) necessarily mean possession, as it were, after the relevant breach of trust. When it could just refer to him having come into possession of the trust property in a perfectly ordinary and lawful way.
Well, I think
In the terms of the trust.
certainly Harrison suggests that that's not right, that you actually, it's to recover trust property. It's all about recovering trust property. And my Lord, can I go back to what I said at the outset, that we're not concerned with remedies here, we're concerned with limitation. There's no doubt, of course, that the director who takes the property and then disposes of it, let's suppose he loses it. He takes the property and then loses it. There's no doubt that when he took it, and for so long as the ordinary limitation period continues, he's liable to the company for having taken the property. But in an action to recover the property, the company can't recover it if it doesn't exist. And the company can't recover it from the director by virtue of some deemed possession, which continues even though the property doesn't exist. But, my Lord, it may be clearer when we get to Harrison. But I just wanted to deal first with the objection raised by Lord Justice David Richards in terms of how this ought to be construed, and to say that that had no regard to the separate corporate personality. It didn't have regard to the way in which you can look through that corporate personality where it has been put there to avoid recovery. And so we say that in accordance with Prest, the corporate personality doesn't give way simply to the justice of the case, exactly what is established. And an action to recover possession of property must necessarily be against the person who has possession. It's as simple as that. You can't recover property from someone who doesn't have possession. So then the question turns on, well, what is possession for this purpose? And we get to control. My Lord Sumption asked about this, and I deal with it now. Now, what we say about that is this. There are very significant difficulties with the concept of possession turning on this word control. Now, it may be that absolute control may equate with possession. For example, a person who has possession and holds as nominee for a director. We accepted below that if the director transfers property to someone, be it a corporation, that holds that property as nominee for the director, then one can say, in a real sense, that the director has possession of that. The position is no different from money in your bank account. You don't have your hand on the coins, but you would be treated as in possession of money which was in your bank account. Not because in the broad sense you have control, but in the sense that the obligations between you and the bank are such that you're to be treated as if that money was actually in your possession.
I mean, the point which was put to you a moment ago by Lord Briggs is closely analogous to the point discussed again in Williams at paragraph 13, isn't it? MS 492 and 3, where the reason for the pre-1888 rule that no limitation period ran against a beneficiary seeking to recover trust property was explained as being that the trustee's possession, and I think in the case of a director that one has to equate that with control, is not inconsistent with the beneficiary's rights. So the result of that is that equity ignores the misapplication and simply holds the trustee accountable for the assets as if he'd acted in accordance with his trust. Now, if you're looking at a director, one obviously needs to modify the concept to take account of the particular role of a director as being somebody in whom the assets are never vested, but who is treated as having control, and that is treated as creating a legally equivalent situation. But the critical point is the relationship of the trustee to the assets at the outset.
My Lord, I agree with that, but what we're concerned with is this question of recovery of the asset and possession, because that's what the Act says. So there is a director who acts contrary to the interest of the trust by disposing of the trust assets in, let's say, an unauthorized manner, but not to himself, is subject to the ordinary limitation period under section 21(1)(3). The question is, what is it that brings 21(1)(b) into play? The answer is, well, if the director continues effectively for this purpose, or let's say the trustee continues in possession of the trust property because he's got it in his pocket, at what point does limitation start to run? And the answer is, for so long as he's got it in his pocket, it never starts to run. Now, the question as to what happens when it's out of his pocket is the question of possession, and that's what we're looking at with respect.
Well, take an ordinary trustee, not a director, in whom the assets are vested. I think the position is that if he misapplies the assets which are vested in him, equity will simply ignore the misapplication and require him to account. And that is because his possession of the assets before he misapplied them was perfectly consistent with the obligations to the beneficiary. Now, if you apply that to the position of a director who is, as the authorities show, to be treated as a true trustee, don't you have to apply it to the way in which he exercises his control over the assets?
Well, with respect, my Lord, the position of a true trustee who misapplies the assets but is not in possession of them is governed by section 21(1)(3), section 21(3).
Oh.
Because it says, subject to the preceding provisions of this section, an action by a beneficiary to recover trust property or in respect of any breach of trust, not being an action for which period of limitation is prescribed, shall not be brought after the expiration of 6 years.
Can I try this?
Yes, my Lord.
It's at the end of your answer. I don't want to shut you off. Just look at an ordinary trust and apply section 21(1)(b) to it. The trustee was originally in possession of the trust property. If he's still got it but is refusing to acknowledge that it belongs to the beneficiary, then it will be an action to recover the trust property which is still in his possession. If, on the other hand, his misapplication isn't a denial of the beneficiary's title while retaining the property, but dissipating it for his own use or swapping it for something else for his own use, then it will be previously received by him as trustee before any breach comes along, and the breach will be the conversion to his own use. And then the question is, has he converted it to his use or to somebody else's use? Yes. If it's somebody else's, it's a 6-year limitation period. If it's to his use, there isn't.
Yes.
Isn't that the right analysis where there's no company involved?
My Lord, that is.
Well, if you apply that to a company, if the director is sitting on a piece of company property and denying that it belongs to the company, the beneficiary in this situation is the company, as I understand it,
Yes.
then it will be in his possession. If, on the other hand, the beneficiary has misappropriated, that the director has misappropriated it for his benefit or use, then the same will apply regardless of the fact that the misappropriation means that it's no longer in his possession or in any sense.
Well, we come to that because the question is what the Act means when it says received by him. And
Well, previously received.
Previously received by him.
Well, that's where his quasi-possession of it as a director, his directorial control over it, is equivalent to previous receipt.
Well, my lord, that was the answer in the Pantone case.
Yeah.
And I need to address the Pantone case, and I will do if I may. But,
All right, well,
my lord, that's a point I need to deal with. But on the question of control, I just wanted firstly to ask you to look at a passage in Thorne and Hurd, which is at electronic bundle 342 to 3, and it's at bundle 1, physical bundle tab 5 of bundle 1.
Thorne and Hurd.
Thorne and Hurd.
Yeah.
And the passage is at, say, 342 to 3 electronic bundle. The passage physical bundle is at 606. And this is dealing with the question that I think my Lord Sumption raised. And you'll see the 3 categories at page 606, the first full paragraph concerning Section 8. And for these purposes, we needn't deal with any material difference between the sections. Dealing with Section 8 of the Trustee Act, which provides limitation periods for trustees, contains 3 exceptions. 1, frauds, to which the trustee has been a party or privy. 2, cases in which trust property is still retained by the trustee. 3, cases in which a trustee has converted property to his own use. My Lord Briggs example. The 3rd exception need not be further alluded to in the present case. We'll come on to that. But if we can pick it up just at the 3rd full paragraph on the page, it was next urged the case fell within the 2nd exemption and that the defendant still retained the plaintiff's money. This again, however, in my opinion, is not true. In fact, the word still refers to the commencement of the action, and the use of the word is important. A trustee may be liable to make good trust money with interest as if it were still in his hands, and yet he may not, in fact, have it. My Lord, that's the point I think my Lord Sumption was making to me. Or the contrary, was making the contrary point to me. But in construing this statute, we have to ascertain whether, in fact, the trust property sought to be recovered is still retained by the trustee. That question ought to be answered in the affirmative if he or any agent for him has it so that he can get it. But in the negative, if it's been lost, whether by his negligence or otherwise. The 2nd exception applies to and is confined to cases in which, at the date of the writ, the trustee still retains, that is, has in his hands or under his control, and that word control, I'll come to what that means, he has in his hands or under his control the trust property, the proceeds thereof sought to be recovered. The 2nd exemption assumes that the property sought to be recovered exists and can be recovered. So it is about the trust property. It's not about anything else, it's about the trust property. And the question of control, when one looks at the trustee having it in his hands or under his control, it means under his control, he has it so that he can get it. And that's the important distinction here.
Does it matter that the word still doesn't appear any longer in the section, or is that?
I think it doesn't matter, my Lord. Because if that were the case, the 2nd element of the 2nd limb of has it in his previously received it and converted it would always apply. Sorry, not always apply, but would be an equivalent. But the having in possession, it must mean still, my submission. That's what it says. Because it is, and again, one bears in mind, it's only in the case of an action to recover trust property. So if you're not going after the trust property, it doesn't apply. And the trust property can't be in the possession of two different people. It's in the possession of one or it's in the possession of the other. And this constructive possession that Lord Justice Lindley was referring to there, my submission, as he says, it isn't enough. Now, interestingly, we say this was actually the answer in Prest. And at 753 of the electronic bundle,
Seven five three.
753,
Yeah.
Not in my bundle, which
Is in mine.
page 360 is where it starts.
I'm so sorry, yes, 360 is where it starts, but the relevant passage.
And it finishes at 455.
So,
Well, if you tell us the
Part that I'd like you to look at.
paragraph number, please.
It's paragraph number 43. So perhaps one,
Page 373 in MS.
Yes. And the answer in Prest was resolved at paragraph 43. Paragraph 42, there's the question of whether the corporate veil had any reality. The problem about this is that if, as the judge thought, the property of a company is property to which the sole shareholder is entitled either in possession or reversion, and it's not uninteresting that Prest was actually a possession case itself. The question was whether there was possession. Was the shareholder in possession of the company's property for the purpose of the Matrimonial Causes Act? The answer is it wasn't, because of the separate corporate personality. It's exactly the point that's being dealt with at paragraph 42. And this is what, say, when we start dealing with this tricky question of control and corporate personality, the problem is that if, as the judge thought, the property of a company is property to which the sole shareholder is entitled, either in possession or reversion, that will be so even in a case where the sole shareholder scrupulously respects the separate personality of the company and the requirement of the Companies Acts. Proposition only justified only by asserting the corporate veil does not matter where the husband is in sole control of the company. It's exactly the same point here. It's plainly not the law. And then beneficial ownership of the property. So this was the solution. It follows from the above analysis the only basis on which the company can be ordered to convey the 7 disputed properties to the wife is that they belong beneficially to the husband by virtue of the particular circumstances in which the properties came to be vested in them. Only then will they constitute property to which the husband is entitled, either in possession or reversion. It's exactly the same point here. If the property is transferred out of the trust to a company controlled by the director in circumstances where the law would impose a constructive trust in favour of the a resulting trust in favour of the director, then of course the director has possession of that in the same sense in which in Prest the director had, the shareholder rather, had possession, the husband had possession of the underlying properties, even though they were within the company and even though the corporate veil wasn't lifted. The answer was that because they were held on resulting trust for the for the shareholder, the husband, he could direct where they went. He could get it, in the words of Lord Justice Lindley. That was property that he could get, and he was ordered to do so. But possession within the meaning of the section can't turn upon the vagaries of control, as my Lord Sumption said in Prest. Well, that may be the case of a single member company. But even within that, you can't say that there is possession, because a director who scrupulously acts in accordance with his duties can't be said to be in the same position as one who treats the property as his own anyway, as a matter of fact, as some people do. But control, in any event, is an extremely difficult concept. What does it mean in the context of the Court of Appeal saying possession is when you transfer to a company that you control? There are many different ways in which it can be said you control a company. Here, there are two defendants, and they happen, between them, to have a majority of shares in the company. They weren't a majority on the board of directors of these companies at any point. but they were majority shareholders. Did they control the company? They didn't control the board. Why then is it said they have control? They're not the sole shareholders. They can't take assets out of the company. Indeed, as this very case demonstrates, you can't just take assets out of the company without regards to the entire constitutional, statutory, and common law rules that apply concerning the assets of the company. So you may be able to say to the director, who is a trustee, I require you to return to the company, return to the trust, the property that you have taken from it. And the director says, I don't have it. It's in the company. Now, if it is in the company, then the director doesn't have it, unless you can lift the veil. But otherwise, you cannot say that simply because that director may have a majority of shares in the company, maybe he's got 51%. Well, what about his 49% shareholder? What will that person say about the assets of the company being removed? What about the creditors of the company? What will they say? All the points my Lord Sumption went through in Prest as to why you don't just lift the veil in the interest of justice apply here. All the points which say that possession of the asset, the underlying asset, the company's possession, is not the possession. It's the very same word. It's not the possession of the shareholder, the person who has ultimate control. They apply here as well for exactly the same reason. So control is not an answer. Control shifts. What if a person has control at one point and doesn't at another? Or they have control of the board, but they don't have control of the general meeting. For some purposes, control is considered to exist when there's a 30% shareholding in a company. Control means different things in different contexts. But the only context, in my submission, which the court ought to consider here in terms of possession is the question of this. Can the director get it? Does he have an absolute right to go and get this property? And only then could it be said he is in possession of the property. I say that was the solution in Prest, and that may well be the solution in many, many cases where a trustee transfers assets in breach of trust to a company that they control. The answer may well be that the person is in possession of the company, not because they possession of the property, not because they control the company, but because of the circumstances in which that transfer took place. That may, in many cases, be an answer. My lords, can I then come on to Pantone?
This is the previously received and converted to his use.
This is the previously received point. And the Court of Appeal,
Where is
Justice
that?
David Richards,
Sorry.
Pantone is at, starts at page 582 of the electronic bundle.
And that.
Yes, 581 of the electronic bundle, and it's in physical bundle 2 at tab 15. Was it 12? So? Yes, physical bundle 2 at tab 15. Now, Pantone is not, can you give me this? Paragraph 41. If we can go to page 593 of the judgment, and just pick it up at paragraph 40, you'll see that the deputy judge was referred to Paragon, Thackeray, and Harrison, which we'll come to. And then paragraph 41, Mr. Bain was lawfully appointed a director of Smart Urgent and therefore came into possession of the company's property by a lawful transaction. The claim against him is therefore within 21(1)(b) if in causing Smart Urgent to pay for the acquisition, he converted the company's property to his own use. It's my Lord Briggs's point that who asked, is it right is it the case that when a director is appointed a director of a company, he is thereby in possession, he has received the property for the purpose of the Act, and that's what we have to consider.
He talks about came into possession, but the words of B are previously received by the
Previously
trustee.
received, and that's the thing here. So that's the base on which the Deputy Judge proceeded, without argument on the point, it seems. He then relied on Harrison, 42. In Harrison, the defendant director acquired property from the company of which he was a director without disclosing the company information that affected its value. He thereby failed to ensure the property was sold at full value. After he had disposed of the property, he was sued for breach of fiduciary duty more than 6 years after he had committed the breach. The Court of Appeal held that the claim was within Section 21(1)(b). The director was a trustee within the provision and had converted property to his own use. The claim was therefore not statute barred. Now, what the Deputy Judge did there was, with respect, to squash up, to close up the reasoning of Lord Justice Chadwick in Harrison. And so I say that that is a misapplication of Harrison. And if we can go to Electronic Bundle 572, tab 14, you'll see the passage in Harrison. Harrison was in some senses, a very straightforward case, because it was a case where the director purchased the property from the company, and then that purchase was impugned subsequently when certain matters came to light.
Then he sold it on.
Then he sold it on. So it's a straightforward case of the director actually having physical possession. Well, I say physical possession of the property. I suppose he did walk around it, he started to build things on it, but he had possession of the property and then he sold it on.
But the misapplication was his acquiring it from the company in the first place, not his selling it on, as I understand it.
The misapplication was his acquiring it from the company without disclosing that planning permission was more likely than not to be.
So selling it on was a further misapplication if he was a constructive trustee on original acquisition.
Yes.
But the one that mattered was the original acquisition.
The one that mattered was the original acquisition. But the point is that by... yes, well, if we can leave to one side any further breaches of trust which may exist and just focus on the analysis in this case. Now, the...
I only asked because if he hadn't sold it on, I suppose he could still have been in possession.
He would have still been in possession, exactly. It's very straightforward then.
Yeah.
He was in possession. And if one goes to... Sorry, my Lord Zine. Yes, if we can pick it up, please, at page 572 of the electronic bundle. In the judgment, it's...
Sorry, this is where it's still on.
If you give us a paragraph number, that's probably...
Sorry, page 572 of the electronic bundle.
Paragraph.
And paragraph 29. Could I ask you to read that, please?
Yes. Yes.
Now, would you then turn to electronic bundle 577, and it's paragraph 39 in the judgment.
39.
Yes.
Yes?
Now, what Lord Justice Chadwick is identifying there is the position of what has happened where the company director has taken a transfer of the company property to himself. That is the trust property, and paragraph 39 makes that clear. The trust property, for the purpose of section 21(1)(b), is the property which has been transferred from the company to the director.
And we had to go
And the
on
present
paragraph.
action is not an action to recover trust property in the possession of the trustee. It is an action to recover trust property, or the proceeds, but it's not an action to recover it in the possession of the trustee. So he then goes on to deal with the question of possession.
Well, he goes on to deal with the question of previous receipt.
Yes. He then says trust property previously received. But the trust property, which is previously received, is trust property by virtue of the transfer of the company's property to the director. That's what he says at paragraph 39. The trust property is the property which has been transferred from the company to the director.
But it was already trust property before that.
He's not saying it becomes trust property by virtue of the transfer, because that would make him a Class 2 trustee.
But with respect, what's being identified here is an action to recover trust property. And it's only when it's in the hands of the director that you can first recover it. So the question here is the possession of the property by the company sufficient to treat the property as having been received by every person who happens to be a fiduciary in relation to that company? Now, as a matter of practice, that will simply not be right. A director, let's take a director who's in a minority position on a board. Let's take Mr. Harrison. The property there was transferred by a resolution of the board in which he didn't participate. So it was transferred out to him. It was a colourable transaction because he didn't make disclosure of that which he ought to have made, being a fiduciary, and the transaction could be set aside. But to talk about Mr. Harrison receiving the property and converting it to his own use, there was an intermediate stage. He actually came into possession of the property. He literally received the property and then he converted it to his own use. So Harrison wasn't a case where you say, well, the director, I mean, let's suppose the director had ceased to be a director by the time he sold it. It would be hard to say that his purchase of the property was converting it to his own use. That wasn't conversion to his own use. It was the sale of the property that was the conversion to his own use. Property that he had received and which in his hands was held by him on trust for the company. And that's the conversion that took place in J.J. Harrison. It wasn't a case of a director selling property out of the company, if you like. It was a case of the director receiving property on a sale from the company. That wasn't a conversion, that was a sale. It may have been a colourable sale, but it certainly wasn't a conversion. So if in J.J. Harrison, there could be no doubt that the previous receipt of the property in this context was the actual receipt by the director and the subsequent conversion. And if the director had ceased to be a director between the receipt and the conversion, that would make no difference. You wouldn't say that when he sold the property, having ceased to be a director, he was somehow released from any obligation associated with that property. That had arisen by virtue of the colourable transaction by which he took the property. And that's what gave rise to the property being the property which the company sought to recover. And again, one has to come back to that. This isn't a question of holding directors accountable. This is a question for particular limitation purposes of saying, is this an action to recover the company's property? And for that purpose, it's not the case if it is simply a case of the director having benefited in some way from trust property while he was a director of the company. That's a very different matter.
Do you challenge the identification of the purpose behind the section given by Mr. Justice Kekovich and Reed Timmis? Which Lord Justice Chadwick relies on.
Yes. He's received something, he's come off with something he ought not to have. That expression, I think, is what my lord is.
By some legal or technical wrong falling short of dishonesty or moral obloquy.
Yes, he's come off with something he ought not to have. My lord, the question is, has he come off with the company's property that he ought not to have? That's the issue. The action only works, or the limitation exception only works, in respect of a claim to recover property against a person who has taken that property or has taken it and converted it. So, in other words, the reason that it's received and previously received and converted to his own use is because if he doesn't have it, he can't say, well, I sold it so I don't have it anymore. That's my answer. He has previously received it and converted it to his own use. He's come off with something that he ought not to have. Now, if he receives the property and then loses it by negligence, well, Justice Linley says, well, the second exception doesn't apply at all. He's certainly taken something he ought not to have, but that's a different question. So one has to look closely, in my submission, at the wording of the section and say, well, what does possession mean, firstly? It's not equated with control, unless it's absolute control in legal terms. Secondly, you have to say, is this something that was received by the director? And again, one can think of different of trustees. One trustee may hold the kitty for the trust. Other trustees may not. There are real issues about possession. And if a trustee acts in breach of trust and benefits thereby, that doesn't mean that he has converted property to his own use. If a trustee sells property and says to the purchaser, don't pay into the trust bank account, pay into my bank account, he's received the company's property. He hasn't converted it to his own use. He's received the company's property, namely the money that was owed to the trust by the purchaser of the trust property. That's a simple misapplication of trust property. That's very straightforward. So, my lords, the question then turns on conversion. And even if I'm wrong on the question of property, the question is, has this property been converted? Now, conversion of property is denying the owner's title to that property. That's straightforward. But it can't be said that by distributing the vital share to BHUH, the defendants converted the share, because the distribution assumed and depended upon the company having title to the share. The company can only distribute that which it has. It's rather like a sale. If a company purports to sell property, that property isn't converted by the purchaser. The purchaser isn't denying the company's title. It may be the sale is colourable, but nonetheless, there's no denial of the title. The purchaser is acknowledging that the company had title. And in a distribution, it's the same. The shareholder can only receive from the company that which is the company's to give.
That would be so in the case of a lawful distribution, but isn't the whole point of this case that it wasn't a lawful distribution?
Absolutely, my lord.
So it was really just a taking, which couldn't properly be clothed with the language of distribution.
But, my lord, the setting aside a distribution as being unlawful does not mean after the event that there has been a conversion. What happens...
Why not, if it wasn't lawful to remove the asset from the company?
Because there was no denial of the title to the company at that stage.
Well, there was on the footing that the distribution was unlawful, there was an unconditional removal of the assets from the company.
Yes, but my lord...
That is not consistent with the company's title.
My lord, but the directors, when they make the distribution, are not denying the company's title to the property. They are saying, here is the company's title, and we're distributing it to the shareholders.
Provided it's lawful.
As members of the company.
If it's unlawful, the act of registering somebody other than the company as the holder of the share in the books of the subsidiary surely denies the company's title, doesn't it?
Well,
it's saying that the company doesn't have title anymore, somebody else does.
Well, my lord...
And the only question is whether that was to his use.
But the reason that happens is because the company's entered into a stock transfer in which the company has passed over the title. Now, that may be set...
That was invalid. It was an unlawful...
Well, my lord, it's effective.
Sorry?
It's effective. My lord says it's invalid. It's valid until it's set aside. The fact is that transfer is valid. The question of denying title might be when the company then goes to BHUH and says, I want that money back, that may be a denial of title when it turns out that after all the distribution was unlawful.
Well, that assumes that the company continues to have title to it until that moment comes.
Well, my lord, it would have to set aside the company would have to set aside the transfer. So there's it's simply, we say, a misuse of language to say that a purported distribution amounts to a conversion. If the director goes and puts his hand in the till and takes money out, he may have converted it. But if he goes through a process which assumes that the company is giving away its asset freely, it's not being converted. Well, the fact that process can be set aside as a matter of law doesn't mean that after the event, that which wasn't a conversion becomes a conversion.
So if you take a simple case where the director procures an unlawful dividend to be paid to a company controlled by the director, you say that there's been no conversion of those funds until it's set aside. Because until then, you say, it's got to be treated as a lawful transaction. Is that the...
My lord, what I say is that for so long as the company itself has clothed that transaction with its authority, then it can't be a conversion. That's what I say. So if, as in the case of J.J. Harrison, the company agrees to sell property to a director, that director cannot in any sense be said to have converted the property. The sale may be set aside. The sale might, for example, might even be unlawful. There may be some provision that makes it unlawful because it's a connected party transaction or something of that sort. But nonetheless, it's simply a misuse of language to say that something has been converted to your use when you have acquired it by a transaction in which the donor voluntarily gives it to you.
Well, that voluntarily begs a number of questions when the director is exercising his control over the company in such a way as to remove the company's assets to somewhere under his own control.
Well, my lord, the issue, of course, the issue of whether the director, as I say, has put his hand in the till and then leaves a receipt saying this was a dividend is very different from when the board gets together and approves a dividend. If that dividend is after the event held to be unlawful, that can't be characterised as a conversion. Something can't be a conversion after the event. It was either a conversion when it was done or it wasn't.
Well, you have 10 minutes left, Mr.
Yes, my
Chair.
Lord. I'm going to move on to section 32.
Yep.
My Lords, the company continues to run a section 32 defence, notwithstanding that fraud has been pleaded. Section 32 responds only to a deliberate breach of duty, and the claimant now pleads fraud. So the assumed facts against which this allegation has to be considered is a deliberate breach of duty, which is not a fraudulent breach of duty. The provisions of section 32...
Can you just help me with that? I'm just trying to understand what kind of, in our context, where you're talking about the conduct of a fiduciary, does deliberate just mean he does it consciously knowing he's doing it, or knowing that it's in breach of duty?
Knowing it's in breach of duty. That's clear.
That's going to be fraud, isn't it? Or dishonesty, at any rate.
Well, my Lord, there is exactly that interesting question about why the defendant continues to run the section 32.
Well, never mind that. I'm more concerned with construing the section at the moment.
Yes.
I'm trying to get my head around the concept of a non-dishonest, deliberate breach of duty by a fiduciary.
Yes.
I suppose it could be where you think that it's one of those judicious breaches of trust that benefits the beneficiary.
Exactly. Yeah. You may say, I know this is beyond my power to invest in these shares.
But it's such a good deal, I'm going to do it.
If I leave them in the bank, it's earning nothing, and my powers don't extend to investing in this. And that's the sort of judicious breach of trust. It may be that that's the sort of circumstance we're concerned with. How that applies to these facts, we would have to see. But there it is. But, my Lords, can we then quickly look at the section itself? I've got the electronic reference to section 32. Well, very quickly, section 32, the Limitation Act. In the physical bundle, it's at tab 4. The first bundle, it's at 330 of the electronic bundle.
Yes.
And could I, for our general submissions, to save time, can I refer you to our written case? But there's just one thing I wish to add to our written case, and it's this. Would my Lords note the distinction in subsection 2, section 32, between the deliberate commission of the breach of duty in circumstances in which it's unlikely to be discovered for some time, and the deliberate concealment of the facts involved in that breach of duty. You'll see that there's a distinction drawn between discovery of the breach of duty and the facts involved in that breach of duty. They're different concepts. And what we say is this, that where a person acts overtly, the act which constitutes the breach of duty is overt, then it can't be said that that will not be discovered for some time. So the payment of the dividend was done overtly. It was done on notice to HMRC, it was done on notice to the secured creditor, it was advertised in the press shortly afterwards, it was done with the solicitors and accountants. We say that was overt. If it turns out that that was an unlawful dividend and a breach of duty, it was done overtly. And it's the threshold test is simply not met. Namely, it's not a case where the duty is unlikely to be discovered for some time.
Discovered by whom?
Well, my Lord, in this case, discovered by the world. So far as creditors are concerned, discovered by creditors. So far as directors are concerned, discovered by those directors not interested in the transaction or who didn't take part in the...
It was discovered by the person who subsequently sues, isn't it?
Well, that's the company.
The beneficiary.
My Lord, in this case, that's the company.
Yeah.
So let us say a director who knows what's going on, but who isn't interested in the transaction, or a director who doesn't vote at the board meeting. Right. Then that person, we say, could not have been unaware of this breach of duty.
That's on the footing that he wasn't involved in the facts which constituted the breach of trust.
That's on the basis that he isn't a wrongdoer in respect of that breach of duty.
Yeah.
So on that basis, we say the Court of Appeal was wrong to elide the expression to not discovered for some time with the fact that only a very short period of time would be necessary in this case to come within the limitation period, something like 3 days. But what the Court of Appeal was doing was aligning the question of what some time means with the question of whether, in accordance with section 32(1), the plaintiff could with reasonable diligence have discovered the fraud. You don't even get there until you're past the threshold test. And Lord Justice Lewison, in which case? In the Wetherspoon case, we've referred to it in our case, referred to a distinction between an immediately apparent injury, such as the loss of a limb, with something which won't be discovered later. And in the Wetherspoon case, he said specifically, well, look, this was all done in secret, and that is an indication that it falls within the subsection. But something that isn't done in secret, this is equivalent to the loss of the limb. This was the loss to the company of the greater part of its assets. That's the claimant's case. Well, the loss of the greater part of its assets was immediately apparent to the world, and certainly to those members of the board who were not interested in the transaction. So on that basis, it can't be said there was no secrecy. It can't be said that it was unlikely to be discovered for some time within the meaning of the section. And some time, as I say, can't turn on how long the period would be were there to be some period of inquiry after the event. It's a threshold test, which is to be equated with deliberate concealment. So we're dealing with someone who knows they're in breach of duty, who hasn't actually concealed anything, but is treated as if they'd concealed something, effectively on the basis that they can say, well, no one knows about this transaction, and therefore I'm safe from inquiry. I don't need to conceal anything about it because no one's going to look. But that's not the position in case of an overt transaction that's entered into in this way. That's not just entered into on the spot, but is the culmination of a series of steps that have been planned for some months, and which is done with the assistance of solicitors, accountants, and so on, and with the knowledge of all the board. It's difficult to think what could be less overt than that. It's not the facts that have to be overt. That's a very different point. The question is, can someone see the transaction? It's up to them. If a director goes into the boardroom, opens the safe, and takes £10,000 out of the safe, that is overt. It's not a question of whether the director has said to the board or not, this is for my expenses or something of that sort, or whether he thinks that his expense receipts won't be looked at for some time. The point is, it's an overt act. And just as the loss of a limb, so the loss of the company's most valuable subsidiary was an overt act. So anyone who was on inquiry, who was looking after the company's interests, namely those directors not involved in that overt act, were in a position, on behalf of the company, to see that act. And they knew about it when it happened. It wasn't undiscovered for any time. They knew it was coming. There was a planned step. The directors knew it was going to come, and it happened. So no secrecy, no concealment. The threshold doesn't apply. So the question of how long it would have taken someone to investigate is neither here nor there, because one doesn't get into the second limb, because you're not into the threshold at all. My lords, those are my submissions on section 32, unless I can assist you further.
Thank you, Mr. Parfitt.
My lords, the role of the court is to give to section 21(1)(b), 1980 Act, the effect which Parliament must be taken to have intended it to have. And if we consider that in the context, first of all, of the paradigm case of the express trustee, we say it is obvious that an express trustee who breaches the trust by first taking the trust property into his possession, adverse to the beneficiaries, and then converting it, is within section 21(1)(b). But in our submission, it is not a requirement of section 21(1)(b) that the express trustee's breach of trust must consist of first taking the property into his own possession for himself, adverse to the beneficiaries, before he then converts it to his own use and ceases to have possession. We say that where an express trustee breaches his trust by converting the trust property to his own use, it cannot seriously be suggested that Parliament must be taken to have intended that such a trustee be able to plead a limitation defence. Unless he has...
We're construing the words of the statute. We're not trying to guess what Parliament might have intended, unless, so long as the statute's clear.
Well, in my submission,
I'm starting the wrong end.
What I began with was what Lord Mann said in Williams and Central Bank of Nigeria, paragraph 157, that the court's role is to give to the section the effect which Parliament must be taken to have intended it to have. Now, obviously, one's circumscribed on that inquiry by the wording used.
But we are in the light of the mischief and purpose, if ascertained.
Indeed.
Does your submission go any further than that?
Well, the submission goes to the fact that, yes, one takes account of the policy when addressing what previously received means.
Yes.
And obviously the difference between a learned friend and myself is that he says the reference to receipt has got to be a receipt as a result of or post the breach of trust. And we say, no, the reference to previously received is a reference to the position before any breach of trust. And the policy of the Act, we say, very much accords with that view of the way in which the words are being used.
But
because
you accept the basic principle that a Class 2 constructive trust is not within Section 21(1)(b).
Yes.
So,
well, let me just be...
one might say Parliament would have surely intended that to be covered. But
yes, before we get into Class 2, perhaps I should say the three arguments I'm going to be running. Our primary argument is that because the director is a Class 1 trustee, that his control of the asset as a director is sufficient to satisfy the requirement of previously received. That's a primary argument. We say that position is made absolutely clear by a consideration of the position of express trustees, and you have to apply that by analogy to the position of the director. It's the point that that Lord Briggs identified at 1145, that the quasi-receipt by the director constitutes the necessary previous receipt for the purposes of Section 21(1)(b) and the third exception therein. My second argument is going to be that where you have a transfer of the company's property to a company controlled by the directors, the relevant degree of control continues. So you start with a position where the relevant control is as director, constituting the director a trustee for the purpose of Section 21. That control continues into the new company. Therefore, for the purposes of Section 21, he is in possession. Now,
you don't need that if you're right on one. You don't need two.
Sorry?
If you're right on your first proposition.
Indeed. If I forget how I'm on my first proposition, my primary proposition, then I don't need my second argument and I don't need my third argument. But that is going to be my second argument. My third argument is going to be that these defendants, the Fieldings, do hold trust property. And there's no dispute about that. The question is whether or not they hold the trust property as Category 1 or as Category 2. And we say they hold the trust property as a Category 1 because they were directors who misapplied trust property and have benefited thereby, which is not FHR. FHR was a Category 2 case. All proceeded on the whole point being, that, as identified in first sub-C on the limitation question, no misapplication of the company property. This is obviously a case of misapplication of the trust property. Therefore, they hold the trust property, namely the new shares in the holding company VHL, as trust property of the claimant company, and therefore it's an action within the second exception of 21(1)(b to recover trust property that they still retain. Now, I'm sure you've grasped those three arguments, but if I may just break them down, just to be absolutely sure of the point. The first proposition, I say, is if one considers, first of all, the position of the express trustee, one cannot sensibly proceed on the basis that Parliament rationally intended that an express trustee who converts the trust property by paying it away, say, to a company that he owns, is in a position to plead the limitation defence simply because there wasn't a scintilla of time in which he, first of all, possessed it himself. That would be irrational. That would be inconsistent with the whole policy of the section. And therefore, when one focuses on the words previously received, we say it follows from the policy that that is a reference to the position before the breach of trust. The express trustee has received the trust property and he converts it. And we say that that view of the section is consistent with the descriptions of what section 21(1)(b is said to be directed at. That one finds in the Thorn and Head case, where it's contrasted the trustee being in possession, which is the first part of 21(b), as opposed to simply the trustee converting the property. No one says that the trustee is still in possession, and then says, and the third element is, he was in possession and converted, or he was in possession after a breach of trust and converted. The act of conversion of itself brings into play section 21(1)(b. And of course, that is consistent with the whole policy, as stated by Mr. Justice Kekewich in re Timmermans, that it was not intended to protect the trustee where, if he pleaded the statute, he would come off with something he ought not to have. And where there's been an immediate conversion without any prior taking into personal possession adverse to the beneficiaries, clearly the trustee has taken something he ought not to have, and if he no longer has it, it's a conversion case as contrasted with a possession case. And of course the statement of Mr. Justice Kekewich was approved and adopted by the Court of Appeal in J.J. Harrison Properties Limited, as we saw. My Lord Sumption in Central Bank of Nigeria and Williams, paragraph 22, said that the section 21 was concerned to relieve persons who had parted with the assets and had not converted them to their use. Again, if a trustee has simply converted the assets to the use without first taking possession adverse, then it isn't a situation where he's parted and not converted. Now, that being the position of express trustee, and we would consider the contrary to be utterly unarguable, we have to consider how that applies in the context of a director. Now, somewhat to my surprise, I understood my learned friend to be seeking to resile from the notion that a director, prior to any appropriation of the company's property, was viewed as a type 1 trustee. And in my submission, it's not really open to him to do so, because at all times the defendants have conducted this case on the basis that the relevant limitation is governed by section 21 subsection 3. So they are positively asserting, in response to a claim of breach of trust, that they are a trustee within the meaning of section, they were trustees within the meaning of section 21. And we can see that in His Honour Judge Hodges' judgment at paragraph 16, which is page 96, I'm told, of the electronic bundle, or tab 4, page 27 of the appendix bundle.
Well, it's not very satisfactory that this point should turn on an admission if the admission is wrong. Isn't it a stronger point to say that they were right to admit it?
Well, they were right to admit it, but in the context of coming armed with all the cases that show they were right to admit it, I haven't come so armed because I didn't appreciate there was going to be any attempt to resolve from that.
Well,
so it's a mea culpa to that extent, yes. But yes, as my Lord Sumption says, we say that they conceded that because that was very much in accordance with the law.
It's an interesting forensic point, but we've got to confront the argument in any event.
Well, my learned friend's attempt in my submission places far too much reliance on J.J. Harrison Properties, because that was a case dealing with the facts of that case. So where Lord Justice Chadwick talks about the position if the trustee has taken possession of the company's property, he's saying that because that was the fact of the case. He wasn't saying that was a requirement for section 21(1)(b) to apply. And on that basis, therefore, when we turn to the position of a director, the director is a Type 1 trustee before any breach of fiduciary duty, which is why he's able to rely upon section 21 subsection 3, irrespective of any ownership of any property, possession of any property. And again, I may quote what my Lord Sumption said in Central Bank of Nigeria and Williams: the exceptions must apply to the same persons as the rule. So section 21 applies to company directors, and therefore section 21(1)(b) has to apply to company directors, and therefore addressing the relevant notion of previously received, which our consideration of the position of express trustees in my submission has established that that's a reference to the position before any breach of trust. Applying that to directors, then the notion of previous receipt is satisfied by the director's control of the company's assets, which is the very thing that makes them the Type 1 trustee for the purposes of section 21. As Lord Briggs says, it's the quasi-receipt of the director that satisfies the requirement for previously received. And on that basis, we say that there can't be any sensible suggestion that this was not therefore a situation where a trustee converted the property to his own use, given that the property was transferred to a company which they controlled. And that's pointing to the control of the recipient company, not of itself as being a manner indicative of an ability on the part of the trustee to recover the property, but simply indicative of the fact that it was a conversion to his own use because of his substantive majority interest in the company.
I suppose you could test that by an ordinary express trust with a number of trustees, but a misapplication by one of them.
Indeed. An express trustee transfers the property to a company that he controls. That's a.
I mean, you would say
the
possession.
idea is not a conversion.
You would say possession and so forth doesn't mean sole possession. It just means in your possession as a trustee.
Well, indeed, and that's the second argument is to say exactly that, my lord, that in the circumstances of an express trustee transferring to himself as trustee for a number of beneficiaries of which he is one, you would look at his beneficial interest in this new trust for the purpose of saying that he was still in possession of the trust property because of his beneficial interest. there cannot be, in my submission, any sensible notion that the still retains, to use the language of the Section 8 of the 1880 Act, or in possession under the modern language, that requires that there be 100% retention. So in Lord Briggs's case of a transfer to a new trust, it may be that the trustee only holds an 8% beneficial interest, but that 8% beneficial interest is still sufficient, as far as that 8% is concerned, to bring him within the first limb of Section 21(1)(b). And therefore, by analogy, where one's considering the notion of control, and it's easier to see where one's considering the director as the defalcating trustee, the director's control of the property continues beyond his breach of trust into the new company. Now, the fact that they're not 100% owner of the company, and the fact that the interests of creditors may intrude, means that it may not be possible to recover 100% of the trust property. But that does not mean that there isn't the necessary quality of possession for the purpose of Section 21(1)(b). The quantum of recovery is a factual inquiry that would have to be conducted at some point. What are the interests of the other shareholders? Now, in this case, prior to the sale of 30% of the shares of the shares to Scottish and Southern Energy, the Fieldings held 100% of the economic interest in Vital, subject to the D shareholders having an interest on a winding up. So any dividend distribution would have been wholly to the Fieldings. Now, it may be, though this seems unlikely, given, of course, the assumption of the claim is that we are dealing with a business worth many millions of pounds, that the interests of creditors would have intruded to prevent such a distribution. But one cannot assume that that's the position on this summary judgment application. In the words of Thorne and Head, if the question is, as it's posited there, a question of what can be got back, well, what can be got back from these defendants is the economic interest in the asset that was taken by means of their control of the company, leading them to cause a distribution to be made. So the second argument is to say that in possession is satisfied in circumstances where you have control of the recipient company.
I wonder if it really matters. If the trustee, on the demand of the beneficiary, backed up if necessary by the court, can return the trust property because he has sufficient control to say to whoever is acting as his nominee, return it, then he won't be, he will lose his limitation protection because of possession. If not, then he probably converted it.
My lord, yes.
Because he will, if it's what he's done that means he can no longer call for it as of right, well, then he's converted it, perhaps. So that either way, the subsection prevents him relying on a 6-year limitation.
My lord, yes. As you say, if it's in the context of a nominee, the whole point is we say conversion to his use is not sort of effectively two categories. It's identifying the relevant concept. You have taken
that
the benefit for yourself.
Doesn't answer the to his own use point, but it might help understand
My lord, yes.
how the subsection works, as it were, as a whole.
Now, my lord, the third argument is the FHR argument. Now, this was an argument that was run before the Court of Appeal, which the Court of Appeal didn't comment upon. Obviously, didn't explain it in a way that they could understand. I'll try and do better. That is to say that the shares in the holding company, VHL, which held the shares in the Vital company, which was originally the subsidiary of the claimant company, are held on trust because it was always intended that those shares should end up with the Fieldings. This is all part of a pre-arranged plan, that's accepted. Those were benefits consequent upon a breach of duty by a director, who as a fiduciary, therefore, holds those benefits on trust for the beneficiary. That's FHR. I understand there's been no dispute about that. Now, FHR was a case of an agent, but we are, of course, dealing here with a case of directors, type 1 trustees. Now, the mere fact that they are directors does not of itself, based on the Granby Valley case, mean that they hold the trust property, the new trust property, as type 1 trustees. We say the distinction, the relevant distinction under Granby Valley, as is clear from a consideration of the Court of Appeal's decision in first sub C, is whether or not the benefits that are now held were consequent upon a misapplication of trust property, a misapplication of the company's property. Now, if we take up the first sub C decision again, I say that is apparent from a consideration. This is in my learned friend's supplementary authority manual, tab 2, and looking at paragraph 32, one sees that Mr. Justice Norris, at first instance, treated the case as not involving the wrongful dealing with pre-existing assets. And that features, you can see from the judgment of Lord Justice Patton, at paragraph 34. The controversy to which the judge is referring concerns the application of section 21A to the liability of the director for a fraudulent breach of fiduciary duty, which does not involve the misuse or misappropriation of company property which existed during the relevant period of his directorship. And then again at 37, the consequence of this is that a constructive trust will be imposed on fiduciaries in such cases, regardless of whether it is possible to treat benefit or payment received by the agent as derived from property in which the principal had a pre-existing interest. So FHR was focused on that question in circumstances where the property wasn't derived from any pre-existing interest. And to complete the point, paragraph 47, begins above that. This is a consideration of J.J. Harrison, which is this sort of paradigm case of property being transferred. 47, the position is said to be less clear when the director's breach of duty does not involve the misappropriation of company property. Of course, first sub-C distinguished the application of FHR in the context of limitation on the basis that the trust property that was there held on trust by the fiduciary was not therefore the result of a misapplication of trust property. Our case is obviously very much to do with a breach of fiduciary duty involving the misapplication of trust property. It's the transfer out of the share in Vital. And therefore, if one then looks at this question of whether or not the trust property that is now held by the fiduciaries is derived from property in which the company had a pre-existing interest, we say there's only one answer to that question, which is that, of course, it's derived from a pre-existing interest of the company, namely the share in Vital. Now, the Fieldings presently hold shares in Vital Holdings Limited, the company that is the holding company of Vital. The shares of themselves at the time Vital Holdings Limited was incorporated were utterly worthless. No benefit that the claimant company would want to say was held on trust. The benefit that the Fieldings have taken consists of the value that those shares acquired by the company's property, the 100% shareholding in Vital, passing into Vital Holdings Limited, which is what the breach of duty was directed to. It's what the breach of duty always intended, because these were a preordained series of steps, as alleged, and as indeed I think is stated in the case summary. So our third argument, therefore, is to say FHR establishes that the shares in VHL are held on trust for the claimant company. If one seeks to say that we put our case too high by simply allowing FHR, because FHR, on the basis of the Court of Appeal's decision in first sub C, was a Type 2 case, then we say, well, it doesn't matter, because we are dealing with a Type 1 case. So the fiduciaries who hold the new trust property, i.e. the shares in Vital Holdings Limited, are Type 1 trustees. And therefore, this is an action in respect of the company's trust property that is in their possession. And the value of that trust property, we say, is going to be the same as the value of the share in Vital that was extracted from the company. Because, as I've just stated, the 100% economic interest in Vital was taken by the Fieldings by means of the shares in Vital Holdings Limited. So there's no, as a matter of quantum, we say it's highly likely that that claim, putting the claim in the FHR way, leads to exactly the same recovery as putting it on the basis of my primary argument, namely that the quasi-receipt by the directors before the conversion is sufficient for the purposes of section 21(1)(a). Sorry, 21(1)(b). And I think that's subject to your lordships would be an appropriate point to break. And
you finished 21(1)(b).
Finish 21(1)(b).
You'll not be very long on section 32,
I won't be very long. It's up to your lordships whether or not you want to sit for a few more minutes.
No, we'll sit again at 2 o'clock.